Imagine this. You've worked hard your whole life, built a home, saved for retirement, and then when you're gone, the state decides what happens to everything. Sounds crazy, right? But that's exactly what happens in Florida if you pass away without a valid estate plan. In Florida, dying without a will means your estate is subject to Florida intestate succession laws. And that may not align with what you had in mind or what you wanted. And no, scribbling, "give it all to my dog" on a napkin doesn't count under Florida law. Let's break down what really happens if you don't have a proper estate plan in place. 1. Dying without a will in Florida. This triggers intestate succession. Under Chapter 732 of the Florida statutes, if you die with a spouse but no children, your spouse typically inherits everything. If you have children from a previous relationship, your spouse may only receive half of your estate, and then your children get the other half. If you're single and childless, the estate could go to your parents, siblings, or even distant relatives. And if no legal heirs are found, well, the property escheats to the state of Florida. Bottom line, you need a will. Otherwise, the state's formula decides who gets your property. 2. Relying on an outdated estate plan. Florida doesn't automatically update your documents when your life changes. A divorce won't revoke a bequest in your will unless you update it. Florida law may treat ex-spouses as predeceased for certain documents, but not all. Example, if your ex is still listed as your healthcare surrogate on your life insurance policy, they may still have control unless you update it. 3. Thinking a simple will is enough. In Florida, even with a will, your estate still goes through probate. A court-supervised process that can take 6 to 12 months or even longer, and your will becomes public record. It won't help if you're incapacitated. That's where power of attorneys and healthcare surrogates come in. And it won't avoid estate taxes or protect assets from creditors. The good news, as of this year in 2025, estate taxes only come into play for higher income estates, or I should say higher net worth estates. And it definitely doesn't protect assets from creditors. Now, a revocable living trust under Florida law can avoid probate and keep things private and faster for your beneficiary. 4. Forgetting about powers of attorney and advance directives. Florida recognizes a durable power of attorney for financial decisions when you're incapacitated. What does incapacitated mean? Let's say you're in a coma in a hospital, or you no longer have the ability, you may have a severe dementia or Alzheimer's where you can't make those financial decisions. That's typically what incapacitated means. A designation of healthcare surrogate for medical decisions. Who's going to make the medical decisions in the event that you're not able to? A living will. This one expresses your end-of-life care preferences. Without these, your family may need to go through guardianship proceedings, which are expensive, invasive, and time-consuming. 5. Assuming probate is no big deal. In Florida, probate can take months to over a year. We've even seen it take 3 to 5 years. Attorney's fees are often a percentage of the estate, which is typically here in Florida set at 3%. Your estate becomes public record, so anyone can see what you owned and who got it. Avoiding probate through a properly drafted trust can save your family time, money, and stress. How to protect your assets in Florida. Step 1. Create a legally valid will. This is a big issue, especially with self-help documents that aren't created under Florida law. Your Florida will should be in writing, signed by you, and signed by 2 disinterested witnesses. That means people that aren't family or are not beneficiaries. They should appoint a personal representative, also known as an executor. This should be either a Florida resident or a close relative. Handwritten or oral wills are not valid in Florida, even if notarized. You really have to follow the steps. Step 2. Consider a revocable living trust. A trust can help you avoid probate, allow for privacy, and offer more control, like staggering distributions to heirs, and making sure those heirs only get funds for health, welfare, and maintenance. It can also help manage out-of-state property without ancillary probate. If you own real estate in Florida, a trust is definitely a smart move. Step 3. Assign powers of attorney and healthcare documents. Florida recognizes several advance directives. Durable power of attorney allows someone to manage your finances if you're incapacitated. Healthcare surrogate, someone to make medical decisions. Living will, instructions for life-sustaining procedures. These should be updated regularly and comply with Florida statutes Chapter 709 and 765. Step 4, and this one is really important. Update your beneficiary designations. Certain assets skip your will or your trust and probate and go directly to the named beneficiary. These assets are like life insurance, IRAs and 401ks, and payable on death bank accounts. In Florida, these override anything in your will or your trust. So you always need to double check your beneficiary designations, especially after those life changes. And step 5, talk to a Florida estate planning attorney. Florida's laws are complex, and DIY documents often don't hold up. An experienced attorney will draft compliant documents, help minimize your taxes, and avoid court challenges. Lastly, it ensures your plan reflects Florida-specific rules. Estate planning in Florida isn't just about who gets what. It's about peace of mind. Without a plan, the state makes the decisions. With a plan, you do. Don't leave your legacy in the hands of Florida's intestate laws. Create your will, set up your trust, and choose the right people to carry out your wishes, and most importantly, review your plan regularly. If you found this video helpful, hit the like button below. Subscribe and share it with someone who needs to hear this. Thanks for watching. I'm Attorney Shawn. This is Law Impact. See you next time.